we have a keynote address today to frame some of the issues that we're going to take up in the first panel. And as I mentioned earlier, as with all of our speakers, we're not going to spend a lot of time taking you through their many experience and detailed backgrounds. They're all quite expert in their fields, but I do want to say a word about Margaret Kwoka, who's going to be our keynote speaker. Briefly, excuse me, she is the Lawrence Herman Professor of Law at Ohio State University, Moritz College of Law. But Margaret, more importantly from our perspective, I guess, is the leading research in America, I think, on the Freedom of Information Act, how it operates and who uses it, and really a leading thinker about ways to fix it. Her book, Saving the Freedom of Information Act, is due out any day now, I think in a couple of weeks, and we're all looking forward to that. It's, I understand it's been described as a sweeping empirical study that documents how agencies have responded to the large volume of requests and the impact, the deleterious impact that has made on how the Freedom of Information Act works and its ability to be used by journalists and researchers to really get at the types of problems that many people thought it was aimed at. So we're very excited to have Margaret with us today. And you should all go out and buy her book next week. So with that, Margaret, you want to take it away?
Absolutely. Good morning. And thank you so much for that really gracious introduction, Dave. It's really an honor to be here. I appreciate this invitation. And it's an honor to be kicking off these 2 days of just incredible programming. So, the theme of this conference, Time to Seize the Day, is, I feel a little bit more optimistic maybe than others on this. It resonates with so many opportunities we have in this moment to change course, and the Freedom of Information Act is no exception. And as the title of my talk suggests, I believe that now is the time to fix FOIA. But I want to start by talking about what do we mean by fixing FOIA and what is so broken about it? So these are questions that I think require a bit more interrogation. After all, with the federal government closing in on 1 million requests a year, clearly FOIA is serving some interests well enough to keep them coming back for more. And it's not like FOIA reforms are distant memories. We've had recent rounds of amendments addressing everything from agency processing to excessive claims of exemption, needed resources and administration of the law, and other topics. And so what then is it that really needs fixing? I believe we need more fundamental structural reform. And to understand why FOIA needs structural reform, I think we should focus on what I consider to be sort of our first order FOIA users, those requesters who use FOIA for our top tier benefits that we imagine FOIA to confer: public interest, public oversight, and accountability measures. And this group of requesters, of course, includes journalists, watchdog groups, nonprofits, community organizations, concerned citizens. They're the type of requesters using FOIA to uncover information that informs the public about government activities and which forms the basis for accountability, like many of the clients and interests that clinics at this conference represent. So to be clear, I would never advocate that FOIA rights be limited to those types of requesters. But if FOIA isn't working for those requesters, then it isn't doing all the work that we want it to do. And probably it isn't working very well for other people either. And so I'm going to take this opportunity to suggest some of those structural and not incremental reforms that we could take up in this moment of opportunity. And to do that, it's also important to identify what those basic problems are that are encountered by oversight requesters that these structural reforms should be designed to address. To cut sort of straight to the chase, and none of this will come as a surprise to anyone in this audience, the biggest problems for journalists and other oversight requesters are twofold. First, extreme agency delay in responding to requests. And second, the practical inability of most reporters to sue when those requests are denied. So let me start with delay. Much has been said about delay over many, many years. In fact, Congress has often been very focused on delay. So, every year or two, we get a new round of congressional oversight hearings at which invariably the requester community shows up, mostly journalists and nonprofit representatives, and they testify as to the horrendous problems of delay. And at those hearings, usually Congress has called a couple of witnesses from government, some like poor FOIA person from state, to answer impossible questions about what takes so long. And Congress sometimes responds. Right? So recent reforms to FOIA have involved sort of creating a new set of carrots and sticks for agencies to meet deadlines, and adjusting fee structures and reporting requirements and other incentives. I don't want to diminish the fact that some delay may truly be as a result of agency recalcitrance. But these kinds of reforms suggest that recalcitrance is the primary reason for delay, and that if we simply punish late responses or reward the timely ones, agencies' performance will improve. But my research belies this strategy. The primary reason for delay is not recalcitrance, but rather it's the volume of non-oversight requesters. And it's this that I took up in my most recent empirical work. And I think this is the most comprehensive empirical account ever compiled, detailed in my book that Dave referenced that will be released in just a couple of weeks. I've documented how news media requesters are making up less than 3% of all requesters government-wide. By contrast, the vast majority of requesters are not using FOIA for public oversight purposes, but rather to advance private interests. Now, these private interests are sometimes very compelling ones, and they're certainly not illegitimate, much less unlawful uses of FOIA, nor should they be, but they are not primarily aimed at informing the public about government activities. And the reason why this matters is that my look inside FOIA operations across a variety of agencies has confirmed that FOIA processing in large part is designed for and sometimes sort of caters to whatever kind of request is dominating FOIA practice at a given agency, which is to say that agencies have chosen to essentially sort of specialize in serving non-oversight requesters, who are the vast majority of folks they serve. So take, for example, the Department of Homeland Security, which now receives just shy of half of all of the federal government's total FOIA requests every year, outpacing every other agency by an order of magnitude and clocking in around 400,000 requests. And a senior official at DHS estimated that 96% of DHS requests consist of non-citizens' first-person requests about their own immigration records, typically because they're needed in conjunction with either a pending or a threatened deportation case or the application of a new visa or for citizenship. So this estimate is entirely consistent with the data I gathered from DHS's biggest components as well. So I think that's exactly right. But this same official explained that, and this is in his words, that DHS is, quote, trying to build a system that speaks to 90% of the requests that we get. And then also he said, and this is another quote, he's trying to drive down the response time for routine requests as far as possible. And it's not just DHS. So at the Bureau of Prisons, another top FOIA official who's in charge of agency FOIA policy there echoed this very same sentiment. He told me, quote, I put a lot of emphasis in processing simple requests quickly because it's one of the few things we have a lot of control with our metrics. Now, this strategy is sometimes incredibly visible inside agencies. So for example, at US Citizenship and Immigration Services, just the biggest FOIA component of DHS, receiving about 200,000 requests a year, there are entirely separate personnel who do nothing but process non-citizens' requests for immigration files. And those individuals who make up the vast majority of the agency's 250 or so FOIA processors, they're not even trained or qualified to answer any other types of requests, such as ones from reporters. And the thing is, this is an entirely rational strategy. Agencies' FOIA performance is judged by the metrics they have to report, such as aggregate statistics on the numbers of FOIA requests received and processed, average processing times, types of responses, et cetera. And the best way to improve those performance metrics is to focus on the bulk of routine, predictable requests, and not to focus on the comparatively tiny fraction of requests from journalists, which are often, of course, more topical and unique and potentially more resource intensive. In other instances, primarily involving sort of regulatory agencies like SEC and FDA, FOIA offices are spending the vast majority of their time processing requests from commercial requesters who are seeking routine, discrete records such as inspection reports or financial filings or government contract information. And these FOIA offices' performance may be impressive, particularly in the speed of their responses, but only because each request requires looking up a single record. And when those are 75 or 85 or 95% of the requests that agency receives, there's little incentive for them to do anything but prioritize those requests and hire and train processors who specialize in precisely those activities. So what these uses of FOIA revealed to me is that the volume of non-oversight requesters is necessarily affecting journalists and watchdog group requests in a negative way. Congress could and should mandate that agencies consider alternative information delivery mechanisms for sets of records routinely needed by members of the public. I don't think anyone should ever be denied the option to avail themselves of FOIA, but they wouldn't turn to FOIA if they had better alternatives, like public access databases that were made affirmatively available, or individual portals for personal information, or discovery in administrative proceedings. And so I do believe that this is a structural problem, one that isn't remedied by penalizing agencies for missing deadlines. But I do also think it requires Congress to intervene. Agencies could take up these kinds of initiatives on their own, but my interviews with FOIA officials across the federal government sort of consistently reveal that even when FOIA offices seek opportunities to improve agency performance by creating alternative systems, FOIA officials often lack the power in the agency to even make that happen. FOIA budgets are not separate line items, rather they come from the agency's general appropriations. And so extra startup dollars to create a new affirmative disclosure database or portal access to particular sets of records, those extra dollars are really hard to come by. And agency officials told me pretty directly that there is really no incentive for officials to come up with sensible alternatives as a result. FOIA, as it stands, incentivizes the status quo. It incentivizes shoving all of our public's information needs into this singular process. But I think it may be buckling under its own weight. So requirements designed to encourage or mandate that agencies consider a variety of information delivery techniques, I think those sorts of mandates or incentives would obviate the need for this en masse routinized FOIA requesting that is the bulk of our requests. And this is the first structural reform or structural intervention that we need to fix FOIA. The second big structural problem for FOIA that I identified is agencies' FOIA violations are relatively insulated from independent review or practical consequence. So put differently, the right to file a federal lawsuit to challenge agency denials under the Act is sort of just has proven inadequate as an oversight mechanism for FOIA's compliance with the law's requirement. So when FOIA was originally enacted in 1966, Congress understood the importance of independent oversight of agency decisions to withhold records. It just focused that concern on judicial review. And as a result, unlike in other administrative law contexts, Congress provided that courts should review agency decisions to withhold records de novo without any deference to the agency's position. And when the Supreme Court ruled that federal courts' powers to review were limited in some areas of national security in an early case, EPA versus Mink, Congress legislatively overruled the court and reinstated true de novo review in the statute. And so twice we've had Congress insisting that there be full independent adjudication by the courts of executive agencies' determinations to withhold records. The idea of de novo judicial review still sounds good on paper, but in practice, it has proven woefully inadequate. So to begin, getting into court is incredibly difficult and the hurdles are very high. Hiring a lawyer is expensive and litigation is resource intensive. And most requesters, including oversight requesters, including reporters and news media organizations, they can't afford legal fights over records, certainly not routinely. And the changing nature of the news media leaves fewer and fewer legacy outlets that would potentially have the kinds of resources to litigate those denials on behalf of their reporters. In fact, even aside from litigation, one study by James Hamilton documented that FOIA use generally is declining among smaller local news outlets. And so the fact that few reporters can go to court to challenge an agency's failure to comply with the law is particularly troubling because those reporters who have brought FOIA suits have observed the power of independent review. So in a series of interviews that I conducted with journalists who are actually routinely using FOIA, who are still doing so particularly effectively, many of them stress the value of going to court. So for example, Charles Seif, a science journalist and professor at NYU, said that he only started finding FOIA valuable in his reporting when he found lawyers willing to fight his FOIA cases pro bono, including actually law school clinics. The same was true for independent journalist Seth Fried-Wessler, who was so motivated by the success of litigating some of his requests that he co-founded a nonprofit dedicated to linking freelance reporters to pro bono counsel in FOIA cases. The New York Times, pick a big, paradigmatic legacy outlet, provides another perfect example of the power of litigation, where top newsroom lawyer and friend of many of ours, David McCraw, told me that he regularly sues agencies on behalf of his reporters simply for their failure to respond rather than outright denials, and that the lawsuit serves to force the agency into a response. That is, just filing the case can make a difference, even without the court making a decision. But these reporters are real outliers in significant respects. Federal litigation is slow. It can sometimes take even years to reach a conclusion, compounding the problems of delay. And that problem may be getting worse over time. A recent report by the Transactional Records Access Clearinghouse, TRAC, documented that FOIA litigation was facing longer and longer delays, with a pending backlog of FOIA cases dragging on for years. And that's, for those requesters who, clear the hurdle of finding a lawyer, getting into court, waiting through the lengthy litigation process for a merits decision. And then they may find that that merits decision is lacking in some respects as well that matter quite a bit. True independence of decision-making in federal court hasn't always been realized. Despite this mandate for de novo review, many FOIA scholars, myself included, have documented the various ways in which courts nonetheless defer in meaningful respects to agency positions, including by, just to name a couple of examples, invoking the special substantial weight standard for reviewing government affidavits in the national security context, or various procedural shortcuts that are used only in FOIA litigation and advantage the government, such as curtailing discovery. So in an in-progress draft article that Michael Karanikolas and I are co-authoring, we're contrasting the US experience with judicial review with that of a plethora of other countries around the world who have successfully implemented independent administrative oversight rather than relying on judicial review. So some of these oversight bodies have now been operating for decades. So there are currently 129 countries in the world with a freedom of information law in effect. And of those, 82 allow the public to file appeals with an external administrative oversight body, the majority of which report directly to the legislature rather than the executive branch to support independence. About half of those oversight bodies have the power to issue legally binding orders that documents be disclosed, so conclusive and binding orders. Now, sometimes enforcement of those orders requires a court, but in some of those instances, they are enforceable directly with direct sanctions for violating the order of the oversight body without the need for the courts at all. And so in our work, Professor Karanikolas and I have argued that independent oversight bodies provide much broader access to recourse for violations of FOI laws and much more effective remedies to requesters. And as we further document, there are sort of two key features that make such a system successful. First, and I sort of suggested them in my framing, right, the body must be strongly independent of the executive branch. And second, the body must have the power to issue binding orders. Now, independence is crucial because agencies, as we all know, cannot be left to police themselves. My research documents that administrative appeals under FOIA can sometimes be useful tools in some instances, but as they currently stand, those administrative appeals go to a different official sometimes, but always within the same agency. And to the extent that agency policymakers venture to interfere or agency self-interest counsels against compliance with the law, this type of remedy is necessarily ineffective. We've seen examples of this recently. So we had multiple instances of political interference with FOIA operations reported during the Trump administration, demonstrating that agencies cannot police themselves through internal appeals. So in 2019, we saw two different agencies actually adopt expressly political review of the FOIA process. So the Department of Interior implemented a so-called awareness review policy requiring career staff to notify political appointees if those officials were involved in any way in documents that were about to be released under FOIA. EPA did something similar, formally adopting a regulation that allowed political appointees to issue final determinations under FOIA. Worse, the impetus for these awareness review policies, it was overtly self-protective. Both of these policies were adopted shortly after there had been releases under FOIA that led, at least in part, to their respective agency heads resigning from office. So Scott Pruitt, Trump's first appointee to head EPA, Ryan Zinke, his first appointee to head Interior, both resigned after documents obtained under FOIA raised awareness about questions about spending abuses and relationships with lobbyists. And in addition to resignation, awareness review was the agency's response. But then after awareness review was implemented, we had documented instances where awareness review was used to actually interfere with decisions under FOIA. So during congressional hearings, one top lawyer at Interior was actually asked about his role in agency decisions to release records under FOIA, and he said, oh, typically I don't really review those records prior to release. But as it turns out, he had orchestrated delaying production of hundreds of pages of records involving David Bernhardt, who was then the nominee for Secretary of Interior until after Bernhardt's confirmation hearing. Because he had lied to Congress, this incident actually resulted in a criminal investigation. Now, these incidents are obviously egregious, but they're not constrained to one side of the political aisle. In 2010, the Obama administration came under fire when DHS issued a directive that various FOIA responses be reviewed by political appointees for, again, awareness purposes, leading to documented delay of releases even to Congress. So these egregious examples of political interference are telling, but there's also more mundane forms of bias in agency decision-making that are perhaps even more common and influential, but hidden from public view. One former senior FOIA official who worked at 3 different cabinet level agencies told me that the only way FOIA ever matters to agencies' political appointees is when it goes badly, by creating embarrassment or worse. And as a result, she said, career FOIA staff are naturally inclined towards sort of minimal compliance or overly cautious approaches. These kinds of soft pressures, I think, can affect nearly any response to a FOIA request. So without oversight by a truly independent body, political considerations and political calculations will invariably sway some decision-making. The second crucial aspect of an oversight body is the power to issue binding orders. This aspect of institutional design is somewhat more controversial, but ultimately crucial, I think. It's ultimately important, and it's supported by good policy rationales. So to begin, an oversight body should be exercising expertise in transparency administration. And so we should have sort of a high degree of confidence in the outcomes of those decisions. I think also, once an oversight body is established and we've invested the resources necessary to do that, it makes little sense to expend those resources to make the institution, but not to get decisive outcomes from that extra process. It's telling that those jurisdictions around the world with the most celebrated models have oversight bodies with this kind of binding authority, including, for example, Mexico and the UK. And while oversight bodies that issue only recommendations, those are sometimes celebrated as promoting sort of a culture of cooperative instead of adversarial approaches. These do not have to be sort of mutually exclusive strategies. In fact, some countries have oversight bodies with strong binding authority paired with front-end mediation procedures. Many of us hoped that the Office of Government Information Services, or OGIS, created in 2007 amendments to FOIA, would serve this sort of role. And it's doing fantastic work with fantastic people. But despite some strengthening of that institution over time, it has failed to ever been given these two essential features as a structural matter, and as a result hasn't proven to be a true alternative to litigation. So to begin with the power to issue binding orders, OGIS has never been given that authority. It's been designed to serve as a FOIA ombudsman, making policy recommendations and offering mediation services to resolve disputes between requesters and agencies. And at the outset, those mediation services didn't even clearly encompass the power to issue recommendations, though now Congress has granted authority, additional authority that OGIS has used on occasion. But recommendations are not orders, and as a result, at the end of the day, OGIS does not have the power to compel agency compliance with the law. Even more problematic, perhaps, is that OGIS's lack of enforcement authority, and this is not specific to OGIS. This has been cited around the world in recommendation-based models. It may cause administrative oversight bodies to sort of pull their punches a bit. That is, if an oversight body believes an agency is in the wrong, but that agency is unlikely to voluntarily comply with the oversight body's recommendations, it may not want to stick its neck out and issue a recommendation or engage the question. It's also potentially demoralizing to requesters to go through a process that leads to no real substantive change on the agency's part, even when the agency is incorrect. So that's on the issuing orders front. On the other key aspect of design, independence, OGIS is not a fully independent body. It's housed at the National Archives, itself an executive branch agency. And it's also been, it's been unclear how independent it can operate in its policymaking role. So for example, OGIS's mandate to make policy recommendations overlaps to a significant degree with responsibilities from the Office of Information Policy at DOJ. And at the outset, OGIS's recommendations, their initial recommendations, sort of died in the process of executive review at the Office of Management and Budget, which is an expressly political review. And since then, Congress has amended the statute to allow OGIS to sort of bypass OMB, but it underscores the point that OGIS is operating within the executive branch. One path forward to bold reform could involve transformational changes to the structure of OGIS, removing it from the archives, creating an independent commission at its head, granting it significant more authority, and funding it accordingly. Indeed, this sort of incremental approach to strengthening oversight bodies is not unheard of. For example, in Canada, the Information Commissioner was originally limited to making non-binding recommendations, but in 2019, it was granted the power to make binding orders. Maybe framed as a set of OGIS reforms, such a step would be more palatable. The alternative, of course, is to design a wholly new institution from scratch, with the same sets of considerations at play. This new institution could be labeled an Information Commission, as it is in other countries, headed by a multi-member commission protected by set terms and for-cause removal provisions. Or it could be labeled a FOIA court, a sort of non-Article 3 specialized adjudicative body, which is a known type of institution that has been created in other cases involving sort of public rights matters, as FOIA certainly would qualify. Regardless of the particulars of the design of such a system in the American context, it's important to realize that it is not a foreign concept to create an independent adjudicative body to oversee executive branch decisions, especially in instances where agencies cannot possibly serve as disinterested administrators of the law. It's deeply rooted in American traditions of checks and balances, of holding executive branch officials accountable, and of our basic democratic ideals. The time to fix FOIA is now. Critiques of the law based on its various failings have gotten louder over time, including assertions that the law is serving all manner of unanticipated interests and failing to deliver on its basic promises. There's no doubt that FOIA is irreplaceable in many aspects, but if we want to rescue it from its detractors, if we want to realize its full potential, and if we want to improve our democracy, the law needs a significant reboot. But now is also the moment because we have seen the dangers of unchecked executive power, culminating in I hope culminating in the dramatic manifestation of a physical attack on the Capitol. And in the aftermath of that pretty jarring display, I think there is an increased focus on questions of democratic and constitutional renewal, and we should take up that moment. Now, obviously, FOIA is a statutory right, but it has rightly been described as quasi-constitutional or foundational. And I believe that these reforms that we need accordingly are not small ones. They too are foundational. So I look forward to the next day and a half of conversations about how to improve accountability by seizing the day.